Good afternoon, everybody. Are we ready? I don't think there's a sign-up sheet yet. Oh, yeah, it is on. Yeah. I don't know where the sign-up sheet is. There are two microphones here. In the event you have any questions or something, we'll have to pass them around. Good afternoon. Who's new to Keller Williams? Raise your hand real high so I can see. Oh, welcome. You're not going to be scared today. No, I'm Marilyn O'Neill. I'm the Compliance and Risk Manager. And as I told you a little earlier, I've been here 11 years. And today what we're going to do is talk about something. Somebody says, how can you talk the whole time about seller's disclosure? Well, because it's the only document that you get sued by. To me, it's the most important document you will touch, representing both buyers and sellers, but most by listing agents. What I'm going to present to you is, of course, the new changes which are mandated by law. But what I want to present to you are a lot of things about who must provide a seller's disclosure. There's an urban myth about a lot of them, and I think those urban myths are promoted by RE/MAX agents. Because last week I had 6 issues where listing agents were RE/MAX, and they were telling the buyer agent all sorts of tales about why they didn't have to provide a seller's disclosure and why they wouldn't complete things. And the last one who called me on Friday afternoon, I said to him, don't tell me it was a RE/MAX agent. He goes, how did you know? And I thought, well, because this week was filled with them. So we're going to go through that because truthfully, everything I say to you, if I have the context as a listing agent, you need to do this. Buyer's agents, keep your ears open because you may be on a transaction where it's this situation and now you'll be told exactly what you should advise your buyer accordingly. Then we're going to actually go through the seller's disclosure. Not only the new changes, but I'm going to highlight the ones that have somehow evaded those sellers that complete it manually. Not the sellers who go through Seller Shield for free and get it done, because they won't let you sign and date it until it is completed. Every box marked, that's a question. But when agents have, owners who fill it out and they do it either online through dotloop or some other form, but manually, they tend to always forget these things, and I never want you to ever pass along seller's disclosure to any prospective buyer where it is not complete. We have no idea if it's truthful. The only thing we can do is make sure it is completed. That is our duty as a listing agent. If you know something, you have to say something, so we'll talk about that. And so from a listing agent requirements, I'm going to tell you what you have to do, and Philip and I were talking, if you did a listing and you did not use the new form, today you're going to go visit your sellers and say, guess what we need to do by law? So we'll tell you what you have to do so that you can get that done. Then for buyer's agents, I feel for you because you're going to be the recipient of it from the listing agent or a seller, but you're going to have a huge job in the event the seller doesn't provide you the new one as of 9/1, or if they provide you the TREC one. So we're going to go through what you're going to have to do in writing with any buyer that you represent that might be caught because a seller won't do what they are required by law to do. And then the last thing is, I did an interview with an attorney who represents a lot of Keller Williams office, and he, before the Supreme Court of Texas, had this case, and it involved the Melody home warranty. And here's what happens. We have a lot of agents that represent investors who are buying properties and remodeling them, or flippers as we call them. Do you know what I'm saying? That we do, we represent them. And the problem is we only can use our promulgated forms. And our promulgated forms for 1 to 4 family, because that's what an investor has done. They've gone into an existing property and remodeled it. If they don't have the proper language, they could be in very serious trouble with the statutes in the state of Texas because they are subject to the same things that builders are about warranties and stating it. So I interviewed him and he gave me some language that your sellers, in the event they are investors and flippers and remodelers, would hire a real estate attorney to provide this language so that the prospective buyer on the contract will be given notices that will be better able to assist that seller in complying with the law. Again, our 1-4 contracts don't do that. Our new construction and incomplete construction provide those things because, see, it's different for builders and remodelers. They have different statutes that they have to abide by. So we're going to go through that. But before we get started, just as soon as you think you understand the forms and you know what they mean, they're going to change them. And they have proposed changes. That doesn't mean they'll be approved in November, but the likelihood of them being approved is well documented, that they've had a lot of discussion on the previous months, if you've seen all the blog sites. So next month, I'm going to go through the proposed changes. While they will not be finally voted on until November, it has been historically proven that November and December, you're not as engaged with risk management at that time of year as you might be at other times of the year. And my problem is the moment they approve it, they will make it mandatory probably within 60 days. We usually get it the minute TREC releases it. We get it and we can post it as forms that you can use. So you can even use them before they're mandated by law, but I want you to understand them because the onus on you as an agent is that you have a high fiduciary duty. You can't use a form and explain it to your clients and wing it. You must know how to use the forms, what they mean. And so that's what we'll do next month. And basically what it came about is we've been sending a lot of things asking them to do clarity on certain things. And one of them on the third party was based on our suggestion to them, the attorney and I, that had to deal with a bunch of things. And the changes in the contract, though, revolve around leases. And the leases are in paragraph 9 and 10 now, but there are no boxes to mark and nothing to fill in. So who reads it? No one. And what's happened is a lot of buyer's agents have gotten into trouble because their buyer has acquired a property where either there's a lease on the property that the seller may have, or there could be a lease that involved landlord-tenant. So there are two different kinds of leases in the new section, and there are huge consequences if the seller doesn't provide it within so many days. Now the buyer would have the right to terminate the contract. So lots of things that you got to pay attention to, because we sell a lot of properties where a lease is in play on a property and they're just conveyed to the new buyer and they become the landlord. So, and we've also gotten caught on leases of the property that have caused major issues for buyers acquiring the property. Okay, so we'll talk about that next month. But right now we're going to say who has to provide a seller's disclosure. What I am going to tell you is that no one, even if the statute has 11 exemptions, no one is ever exempt from telling material information or condition of the property. No one. Case in point, years ago we had heirs, 3 siblings who were selling a property. Their agent told them, you're exempt. You don't have to fill out a seller's disclosure because the law says you're exempt in settling your parents' estate. Well, that would have been fine if those siblings didn't know anything about the property. After it closed and funded, the buyer found out a whole lot more, that the siblings who benefited financially from the sale of the property. Notice when I say when they benefit financially, that's who gets to be nailed. The statute of exemptions is not going to help them, because bottom line is these siblings in their deposition said that their mother was in a state that anything to do on the property, the roof being fixed, all these other things, all had to be done by one of the siblings or paid for it because their mother was not able to make the decisions. But they didn't disclose all these things. And so they got into trouble. So again, even though the exemption is there in the statute in 5.008, if that owner or that heir or that guardian or that trustee, they know anything about the property, they are never exempt from what they know. They may create their own seller's disclosure saying this is what we know about the property, we don't know anything else, but bottom line is they're not exempt. And never having lived in the property is not an exemption. This is what I love, the listing agents, oh, no, they've never lived in it. They live in California. That doesn't exempt them. They own the property. Then you find out that maybe that investor who's out of state and says they've never laid eyes on it has had the property leased for 5 years. Well, I'm just going to tell you that the courts think that landlords know more about the property than owners. So you see how those agents that assist those investors from not completing it because there's been a tenant in it for 5 years won't work. They're not exempt. An investor purchased in foreclosure is not exempt. We get this all the time from listing agents. Oh no, they bought it in foreclosure. They don't know anything. Oh yeah, they do. They actually remodeled it. Anybody who remodels a property knows something about the property, right? And if you represented a seller and they said unknown on everything, you don't have enough information to put it in MLS. And if you put something in MLS that you don't have in writing from the seller about what's in the property, it looks like it's your disclosure. And if you disclose something and the seller provides everything unknown on the disclosure, it's deadly for you as the agent. Not a good scenario. And again, our duty as a seller's agent representing them in the sale of the property is to help them comply with the law. And this is the law that we're talking about. And so no agent, unfortunately, that agent who said you're exempt because, you know, you're the siblings and you're settling your parents' estate and all this, well, it didn't work. They put it back on who? The listing agent. Okay, and that's not a good thing. It says, do you know why we require the Texas Realtors now 6-page seller's disclosure instead of the TREC disclosure? In the early 2000s, our brokers didn't make a big determination. They just said a seller's disclosure. Well, the TREC disclosure is the minimum requirement of law. I mean, that's it. Texas Realtors, just by looking at it, you can see that it has a lot more questions that a seller is asked to give disclosure about. So what happened was in these lawsuits, they blamed the listing agent for assisting the seller in concealment of information. The word attached to it by the plaintiff's attorney was called fraud. No agent, no one's covered under fraud. That's a crime. So at that point in time, all the brokers said, oh, no, none of our sellers will ever be given the TREC disclosure. They're going to be given an opportunity to tell the prospective purchaser a lot more. That's why we only use our association form, the Texas Realtors one. So again, it's not because we just made a decision. It was founded in assisting the brokerage in protecting and allowing the listing agents never to be accused of fraud and concealment. That's usually what they do, and the DTPA for the state of Texas gives them other rights. And so, again, that's the reason, is we don't want a seller who won't disclose everything. We have found that no seller who discloses too much has ever been sued. And you know, if the seller's sued, all the agents in the transaction get sued. They just sue everybody who breathes. And it's unfair to a buyer's agent too. Do they have any relationship with the seller? Absolutely not. Listing agents do, but not the buyer agent. The buyer agent is hit by surprise as much as the buyers are about it. But yet we get punished because we passed it along. So again, the seller's disclosure, it's important to know the exemptions and what they mean by those exemptions. Otherwise, they must complete it, period. Now, by Texas Property Code 5.008, it says this section does not apply to a transfer, one, pursuant to a court order or foreclosure sale. So if the court mandates that it's done, that when they sell it in foreclosure, they're not required by law to provide it to the buyer who buys it in foreclosure, okay? The buyer who bought it is going to always be subject to it because they're the owner now, but not pursuant to a court order to say, I mandate the foreclosure sale. By a trustee in a bankruptcy, I talked about this last month. Those trustees are usually appointed by the court. Not only do they not know anything about the property, they've never seen it. They're truly independent third parties. Years ago, in settling estates, a lot of individuals would have an executor or an executrix, not somebody who was related to the decedent, but an attorney. Okay, so they were truly independent. They might not have had any firsthand knowledge about the property and that type of thing. The next one is to a mortgage by a mortgagor or successor in interest, or to a beneficiary of a deed of trust by a trustor or successor in interest. In other words, through that type of transaction, that party is not required to give a disclosure to the other party. They're exempt. By a mortgagee or a beneficiary under a deed of trust who has acquired the real property at a sale conducted pursuant to a power of sale under a deed of trust, or a sale pursuant to a court-ordered foreclosure, or has acquired the real property by deed in lieu of foreclosure. That's where lien holders who've had to take the property back when they go to sell it, they're not required to disclose. I'm going to just interject a little interesting thing. Has anybody ever done relocation, represent a relocation company in the sale of a property? It's interesting. Relocation companies are not exempt, but they're notorious for saying they don't know anything about the property, right? They usually attach the seller's disclosure of the employee who transferred title to this relocation company for purposes of final sale and that type of thing. But I'm going to tell you, I did a lot of relocation, and you really become a property manager because you're there taking care of the property, because the relocation company is in a distant building in a distant state maybe. They've never seen the property. They mandate that the listing agent really becomes the property manager. They're the ones who are the first on the scene. We've had cases, lawsuits, where the relocation company told the listing agent, get that plumbing issue fixed. And yet they wouldn't let the listing agent disclose it, nor did they. They're not exempt. The only lawsuit we were involved in with the relocation company, the day the lawsuit was filed, they gave the other party a bunch of money because they knew they were wrong. We had to stay in it for a little bit longer, and it revolved around surveys. But relocation companies know exactly when they've crossed the line or when they have to get out of something because of it. And in that transaction, even though it wasn't about the survey, we found out that the relocation company paid for all the plumbing issues that were done, and yet they didn't disclose any of it to the buyer, our buyer. Now, the next one is by a fiduciary in the course of the administration of a decedent's estate, guardianship, conservatorship, or trust. Again, as long as they don't have any material information about the property, they are exempt. As I said, the biggest issue we kind of get involved in is when an estate needs to be settled. And it just depends. Sometimes the surviving spouse is also an owner and is on the, well, that surviving spouse knows everything that the decedent knew, so they will complete it. And so those are the kinds of things you have to be careful about. If you take the listing, you just verify with them in writing that they know nothing about the condition of the property that's happened in the past or when it was previously owned. Yes, you have to use that microphone. Mm-hmm.
Hi, Marilyn.
Hi there.
I've dealt with elderly couples lately. So both of them are okay, but you can see that they're forgetful. How do you go about it when they're really forgetful and they're saying no to things that...
Well, you have an obligation, and they're looking at what statute's going to require you as a listing agent. I'm frightened for y'all, because if it gets passed, it means you're going to have to determine mental competency. The moment you know that somebody doesn't have recollection, or they're forgetful, or they show signs of dementia, you're no longer able to go forward. Somebody else has to step in their behalf. So this is one of those serious things. You can't be in the neighborhood when they fill out the disclosures. You can't be sitting at the table with them, because it becomes your disclosure. You would absolutely say that you might want to get your children or somebody in the church or somebody there, a neighbor that they trust, to help them go through it. And using Seller Shield online is great, because it gives legal advice as they're going through it, so it might assist them with recollection. My problem is, for sellers, they're not given forgiveness because they don't remember. How omissions, we've had some sad situations. The sellers forgot that a back window didn't open. They don't go in that room. Do y'all have rooms in your home that you don't go in every day? I do, because I finally don't have people living with me for the rest of my life who think they should be. So I don't go in those rooms as often because there's not a lot of people. But you know, really what a seller would have to do if they don't get a pre-listing inspection, which I think is the best framing, the best way to protect them. Number one, I'll talk about that in just a minute. But a pre-inspection would what? The inspector raises and shuts everything, makes sure no seals are broken. You know what I'm saying? They give the true nature of what they found, the condition of the property. Why do you think I had my sellers do a pre-listing inspection report? Here's the issue. A seller doesn't know the true value of their property framed with the condition of the property. You know, they all think their home is perfect and it's worth so much more. The problem comes when a buyer knows and is scrutinizing the property through a different prism, right? And the buyer says, oh, it's going to cost me $20,000 to do this, right? So then their offer is reflective of it. Sellers don't have a position of strength unless they have knowledge about the true cost associated with maybe a repair for their condition of the property. So when we were doing all this, a lot of times they found out it was going to be a $200 fix, and yet the buyers are going to look at it and inflate it 10 times more. So the reason I did that, this is before they had, and this is in the 90s, and it was because I'd had sellers who really looked at their property in a different prism, like everything is perfect, and I'm going to get $1 million gazillion for it. You know, and the reality came very quickly once that inspector, and he was great, he literally went through it. And an inspection for a seller has a lot of different stress on an inspector than one for a buyer. Big difference. And so, and sometimes the sellers found out, oh, I can even do that repair. It doesn't require a license. I can do it because I still own the property. We would never want a seller to do electrical work or, you know, HVAC or roof flashing, things that they couldn't do that really a commercial company or those that are licensed would have to do. But it did help that seller really kind of see their property in a better prism, find out, well, if they want this, it's only going to cost me this much. I might be in a better position to negotiate. And again, the sellers will attach that inspection report, notate everything on the seller's disclosure. So now it's to the buyer's benefit that they're the ones that now have to determine all of this and what they want to negotiate for it. But the seller has been truthful and gone above and beyond. In today's society, I just would not advise the seller not to do that. I'd be afraid. I really would be. I don't want them to leave any money on the table, but I do want them to be able to have a better control of if negotiations are ensued or if the offer reflected because of all this, the seller will go, no, I've already gotten 3 bids on it. I already know what it's going to cost me. That type of thing. You have to use the microphone if you want to ask a question because of live streaming.
Hi, Marilyn. That's a great idea for my elder sellers. I'll do that from now on. I actually suggested that to my elderly sellers, and they said, well, what happens if they find out more problems? I don't want to divulge it. And also, once you have an inspection, I know. Once you have an inspection, don't I have to show it to them?
Absolutely. They have to disclose everything on the seller's disclosure, then attach any inspection report. If they did it, they don't have to black out their name. If it comes from another buyer who terminated because of the termination option, they would have to black out the buyer's name on the inspection report. My thing is, the sellers would rather disclose it and make it up to the buyer than being called after it closed and funded and the buyer said, hey, you knew this and you didn't tell me. Again, the cases that we've been involved in, sometimes the sellers purposely didn't disclose, and the listing agent was hurt by that, horribly hurt by that. And our goal is to get a seller to disclose as much as possible, not conceal something. That's where we wind up in all these litigation. And the problem is it costs quite a bit of money. Once it becomes a lawsuit, you can't just say, well, I want out of it. I didn't do anything. Some judge is going to have to say you get out of it, and that's usually after it costs about $100,000 a year in legal expenses. So again, I'd rather have the sellers know the true condition of their property based on an inspection report and be prepared and have better negotiating ability. That's our job as a listing agent. on something like that. There's a microphone right there.
How you mentioned this, the listing agent can be really hurt by the seller not divulging. In what way could the listing agent be hurt if they are unaware that the seller has not divulged
Well,
something?
I'm just going to tell you, they sue everybody, they keep you in it, then they'll depose you, and the next thing you know, your sellers, we've had sellers who've said, oh, I asked my agent about this, and they said, don't worry, don't disclose it. We've had sellers that actually lied. Buyers too. You know, we never know, and my concern is, this is not getting better. Y'all are in a very bad way here because you listed properties that were flooded. And the moment that seller said it was just a little bit of water, you know what I'm saying? Or you sold a property and the seller said it only flooded once, and yet with a little bit of effort on your part, you would have found out it flooded 3 times. So that's the problem. That's how it is. That's how the courts are. Yes.
What can we do, or what should we do when I was representing a buyer and we were looking at a house and the seller's disclosure showed no issues, but there was evidence of water damage.
Run.
So I don't.
All of
We
you
did,
run.
actually.
Run. Yes. I'm just going to tell you the reality of it. No buyer ever relies upon what the seller says, and if they do, they don't need to buy any home. And that's the truth, because the seller is required by law to disclose this, folks. But that doesn't mean that the buyer is going to believe what the seller has done. The very first paragraph, and we'll go through this when we finish it, is a real reflective, God bless you, of the situation. That's my thing. No buyer would go forward if they know, God bless you, that the seller has. I've seen so many disclosures that the home is just perfect. Nothing wrong, right? And then a 97 inspection report is attached to it the next time. See, that's what I cannot stand. And because that hurts that listing agent big time, those type of things. There's a charm.
Madeline,
Okay.
I just wanted to let you know that I kept on reemphasizing how important seller's disclosure, truthfully, how important it was. And eventually, I think, overdid it. He didn't know whether asbestos was there or not. But then after reading the seller's shield disclosure, he ended up going, well, asbestos, 1962 house, I guess there's some in there. I don't know where, but it must be. So he
Hey,
disclosed.
I don't
So-
care if the seller over discloses, that's fine. That's better than non-disclosure on something. The next one is from one co-owner to one or more co-owners. That happens a lot with LLCs where they might have jointly gone in, they need one member off of it and that type of thing. They don't have to give a seller's disclosure to the other party that is given the ownership. Number 7, made to a spouse or to a person or persons in the lineal line of consanguinity of one or more of the transferors. Basically what that means is if I sold my home to my son, I am exempt. Okay, he's blood related to me. That's what that means. Plus, he knows everything because I've always called him to fix things. So he knows everything. He knows a whole lot about his mother's house. The next one says, between spouses, resulting from a decree of dissolution of marriage or decree of legal separation or from a property settlement agreement incidental to such a decree. This happens all the time. The one spouse who's giving it over to the other, they don't have to give a seller's disclosure. So they're exempt by law. And then 9 is to or from any governmental entity. Well, the government never knows anything. So that you can kind of understand why they would be exempt from the seller's disclosure. We get that a lot with VA. The lien holder of VA takes back the properties, Fannie Mae, Freddie Mac, those type of things, HUD. Now, number 10, transfers of new residents of not more than one dwelling unit which have not previously been occupied for residential purposes. Those are builders' properties. Builders are exempt because of the warranty issues and the statutes of what they have to declare to a buyer. Very different, okay, because nobody's ever lived in the property. 11, transfers of real property where the value of any dwelling, which is an improvement, does not exceed 5% of the value of the property. Here's what happens. The listing agent and the owners have gotten together and they said, you know, I think the best way for us to market this property is lot value only. How you as a listing agent determine if they're exempt under the Texas statute is you'll look at the appraisal district. The improvements on the property usually are zero value or $100. If the improvement is 5% or more of the total tax valuation, they are not exempt. So that's what the seller would be able to, even though they want to market the property for lot value only, they're still required by law because the improvement on the value on the appraisal district exceeds 5% of the total valuation. Okay, so that's how, as a listing agent, you'll assist your seller in making sure if they're exempt or not. Now, I've talked about those. These are Texas law. I just want you to know that federal law, no one's ever exempt from that. That's in particular about the addendum for lead-based paint issues. So those addendums that are required by federal law, like the lead-based paint, you're never exempt from it, even if you're selling it for an estate or for a trustee or any type of individual that's come in to sell. Then the last one was, the statute is very clear. It says to the sellers of the property, you must give this disclosure to that prospective purchaser prior to executed date. Okay? Well, TREC said, sellers are procrastinates. And furthermore, listing agents never do the right thing in timeliness. So they put a provision in the TREC promulgated form in 7B2 that says seller will provide within so many days. Otherwise, the buyer gets a free walk, and they get a free walk within so many days because of this part of the statute. The seller is obligated by law. TREC says, well, we'll make our forms a little bit more forgiving for those that haven't gotten it. But even if they're giving it to the buyer still has a free walk. A lot of investors use this provision and never pay a termination option fee to the sellers. It's a trick that they use because they know when they get it, they have 7 days to terminate or not, and they didn't have to pay a fee for it. Okay, so again, the statute says it must be done before effective date. Every seller we represent would never mark 7B2, ever, if they knew that they were giving the buyer another free walk. Does everybody understand that? Does everybody agree with that? Sellers don't want the buyers to have any more free walks. And any listing agent that doesn't get the seller's disclosure before they put it into MLS, they're running a big risk anyway. Because once a seller gets an offer, the focus is all on that, isn't it? Not necessarily what they're required by law to give to the other party. And if they haven't used Seller Shield or they haven't spent any time, they're going to rush through it. And that is the deadliest thing for a seller to do. This is not one document where you're going to whip it out and sit in front of it. I did one training one time and I made everybody fill out a seller's disclosure based upon the property they resided in. It's not easy to fill it out. It isn't. It does require a lot of effort. When I sold my condominium in Port Aransas, it was a condotel basically. It was a rental property, right? People went down to Cinnamon Shore and they rented it for all that. And it was property managed and we had everything. I had an inspector come and do an inspection report, and then I fixed everything and gave all the receipts and filled out the seller's disclosure through Seller Shield and did all of that. There's a reason for that. I know how people get sued. And we don't live our lives being afraid of it. No, we empower ourselves to do the right thing and our best practices. That's it. We can't prevent people from doing whatever they want to do about suing us, but you can certainly incorporate the best business practices that will be in your client's best interest. And if you ever had a client who will not disclose something, we'll talk about that a little bit later when I talk about the listing agent's little narrative that they're going to have to go back to their sellers and get the new seller's disclosure. So now what we're going to do is we're going to look at the new seller's disclosure. It's 6 pages now. Yippee! Now, it's 6 pages right now, but it can be expanded. And what I've told you in the past as listing agents, You are required to prove delivery to the buyer. That is your job. You have to prove delivery. The statute doesn't say you have to hold a gun to the buyer's head and make him initial, sign, and date. No, but we usually get that because that is the one conclusive document. We don't want it to not be signed by all parties and dated properly. That is a fact. But the seller's disclosure and any attachments that are going to be notated as you go through it are going to be the total seller's disclosure. So it can go from 6 pages to, it could be, if you had a 90-page inspection report, it could be over 100 pages. And you have to bundle it all together and prove delivery to the prospective buyer. And it should be done prior to effective date on the contract, just to protect the sellers from having another free walk. There's nothing that I would ever say that a seller would not have to do. Okay, I can give you the answer right now, and you haven't even asked me the questions. When in doubt, disclose. As I said, the sellers don't get sued because they disclose too much. And we're going to talk about some of the new areas on the disclosure. But first, I want to talk to you about something. Last week, the first RE/MAX agent issue that the buyer agent called me about was on Monday. She says, Marilyn, I've got a RE/MAX agent, and the seller did not complete the questions on the flood, the new flood part, right? It wasn't completed. And so the buyer's agent asked the listing agent, can you get the seller to complete that? Smart. That's what you have to do as a buyer's agent, right? Well, the RE/MAX agent came back and said, no, the sellers don't want to say what floodstone it's in because if it changes in the future, then they might be liable. Well, that's a bunch of bull. I said, tell them. I said, she doesn't read because it's in that first paragraph right at the top of the disclosure. Here it is. It says, this notice is a disclosure of seller's knowledge of the condition of the property as of the date signed by seller. That's why we're hyper about your seller signing your seller's disclosure. Any listing agent who doesn't have that on it and they give it to the next buyer, their seller's already in trouble. It's as of the date. The courts view that. They say, oh, as of this date, that was the condition of the property. Now, if it's past that, they do have a duty and obligation, sellers do, to give further information. But as that point in time that they completed it, that is it. So that RE/MAX agent was absolutely wrong and assisting the buyers in not trusting the sellers at all now. Anybody who gets bad advice, it reflects badly on the sellers and makes them look like they don't know what they're doing or they're purposely not doing something right. Now, section 1 in the very beginning talks about, there's a paragraph, it says seller is or is not occupying the property. We have a lot of people, sellers, who never complete this, and they need to. And it's very clear because it says, well, if you're not occupying it, what was the month and year that you left? Or did you never occupy it? Notice it says never occupied. That's how I know those that have never occupied the property are required by law to disclose. It was so easy to just point that out. It complies with the statute all the time, and that's what you want your sellers to do. And in section 1, it says it doesn't convey anything. It just gives the condition of it, or if it is actually on the property, to the buyer, okay? So through section 1, the part that they miss a lot are the additional information pieces. They might mark that they're central AC, but then they forget to say what kind and number of units. Those number of units goes forward for a lot of different questions, number of ovens, and then the type. If you get down towards the very bottom of this page, you're going to see several questions that says owned, leased. Very important. We had a lot of buyers who thought leased property conveys in the contract. Now, this is a disclosure, right? And what happened is, it usually occurred very late in the transaction, like walkthrough, where the water softener would be gone or something else, and the buyer's going, oh, no, that's in paragraph 2 of the contract. Oh, yes. And this listing agent failed to show that it was always going to be excluded. So listing agents get into trouble on this, and so do buyer's agents. I think when we've got our new little sections, it'll be really great because it's on page 1 of the contract. It's going to be right there in paragraph 4. But what a buyer's agent will have to do until such time that the contract has those new lease provisions, they would have to tell the buyer, these items are not owned and will not convey. A seller can only convey what they own. So buyers negotiate going in. They know because the buyer's agent has reviewed this. Unfortunately, on some issues, the buyer agent said, I didn't go through that and I had no idea. And then they wound up buying. Because they didn't work in the best interest of their buyer, did they? No, that was sad. So again, it's very important to go through this as a buyer's agent. That's why you don't want any blanks, because you're not going to assume, oh, I saw that when we went through the property earlier today. I wonder why the seller didn't mark it. You're not going to make any comment about it. That's the seller's job. But it is your job to go through it. As I said, it should be completed. You never want your buyer to have a signature and date on a document that's not completed, unless you've got it in writing that they said it was okay. Now, at the top of the second page, the first time we are told that the seller's disclosure goes from 6 pages to 8 pages is septic and on-site sewer facility. The TXR 1407 will be attached. So again, instead of 6 pages, now it's 8. You see how, as we go through it, it's going to point out these things. The other thing is, I don't know about you, but it has a question. Was the property built before 1978? Yes, no, or unknown? Okie dokie. As a listing agent, you go through the appraisal district information with your seller and you provide it to them. And usually they have what? Year built. Wow. So they may not know if it's 90 or 100 years old, but they absolutely know if it was built before 1978. So that unknown we see a lot with investors. It's gross negligence on their part. Again, that's what I'm saying. You have to be highly aware of those things as a buyer's agent because there should never be an unknown, okay? And if yes, then they have to attach a page. So instead of 9 pages now, it could be 10, you know, those type of things. It keeps growing. Roof type and age are always left blank. I have no idea, but do you know what these crazy buyers want? A good roof. Have you ever heard of such a thing? Yeah. And when they see it blank, they're looking at it like, what is the seller hiding now? Period. That's exactly how a buyer will look at it. We have a lot of sellers of condominiums that love to leave it blank because, see, they only own from the sheetrock in. Well, then they should put a notation that contact the condominium association for details. That would be what a really good seller would do. Great. The next question, I got asked a lot of questions on this. I hated that. Marilyn, what was a French drain? Well, it's not named for the French people. It's named for Mr. French, who created he's an engineer who created the French drain. See, there are lots of things I know a lot about because of the seller's disclosure. But when a seller turns to you and says, Marilyn, do I have a French drain? You're going to look at him and go, I have no idea you have a French drain. We never answer if the property has it. We may give the Webster Dictionary definition of it, but we're never going to say your property has that because then it would be our disclosure. The next one is about an overlay roof. And I got lots of sellers who asked me if they had one. I said, I have no idea. You might want to get your friendly roofer out here to answer that question because I can't answer it. And then the last question in this section is very critical. It says, are you, seller, aware of any of the items listed in section 1? Remember, they just asked if the property has it. Now they're asking, what's the condition of it? And you have to do that for every one of those items if they're not in good working condition or they're in need of repair or they're defects. That's when the seller would mark yes. That's why we know that sellers don't take a lot of time going through this because we never see clarity here in this question. This is a huge question. And it says, if needed, you can attach additional sheets. We've had some sellers who attached lots of different sheets to it. I represented attorneys when they sold their property. I'm not scared of attorneys. They are human, believe it or not. Some people think they're not, but they are. But what I learned from them, the really good attorneys, is they would attach, sometimes I had a book That was the disclosure. See, they know why they get sued on these type of things. And one of them had, this is the plumbing company that has always taken care of our property for the last 12 years. This is the electrician we always call. And all of it was attached with receipts and disclosure. The whole thing was a book. Now, this is a long time ago before we had electronic, I had to copy it, have extra copies, prove delivery before contract was executed, all these type of things. But what it told me is, the more you disclose, the better, period. Now, Section 2, it asks a lot of items, and they says, are you aware of any defects or malfunctions? And it lists things like we don't even have in Texas for the most part, or basements, whatever it is. The only thing is the sellers tend to forget to mark other structural components. And I don't know if they're thinking, what does that mean? You know, what is the other structural components I have, you know, trying to identify it? Or they just got tired of saying no. Because that's what I see on most disclosures, is everything's perfect, right? On something like that. Well, I'm not going to answer that. I don't know. It would depend upon the property. Yeah, on something like that. So if the answer to any of the items in Section 2 is yes, again, they have to answer if they can't put it all together in these little spaces. I am going to tell you, if you can't read it, don't pass it along as the listing agent. It has to be clear. We had a lawsuit, and the attorneys had to blow it up on a wall in the law offices, and all the lawyers and I were in there trying to figure out what the seller wrote. Isn't that crazy? And if we couldn't see it, even blown up, no buyer should have ever signed it. It should have been clear, okay? The reason I love Seller Shield, not only is it free for the sellers, but it expands the disclosure based upon how much the seller discloses and writes. It's wonderful. And you can read it. Very clear. It's wonderful on that part. Now, Section 3 is smaller. And the reason is they took every question out about flooding events from Section 3. The governor really wanted those sections to jump out and be really prominent for a buyer to acknowledge and see. So they removed all that. But what I want you to do is go on the right column, about midway down, there's the word that says water damage not due to a flood event. Does everybody see that? Water penetration is not on here anymore. You know what this water damage is? It means if the property is 60 years old and the seller didn't own it the whole time but knows what previous events happened, they will have to disclose every water damage that ever happened on the property and explain it. Not just while they own the property, any. And that is one of the biggest things we have issues with, is water damage. Can you repeat that again? Say it again. Any water damage. No, you said 60 years. So if the sellers of the property have only owned it 5 years, but the property is 60 years old and they are aware that there were previous water damage issues, they must disclose it. It's not just while they owned it, it's the history of the property. And there's where sellers get into trouble. They might have had an overflow from the HVAC, flooded it, and they took care of the ceiling and all that. They have to disclose it.
Right, and that's where you would mark it.
Yes, and they're going to attach pages because it won't fit in those 3 little blanks. Here's what I'm going to kind of tell you has happened to us. A seller has disclosed that we had water damage due to a roof leak, and it came in and we had to replace the ceiling in the master, all these different things, or that the shower pan leaked and we had to replace all of that in the bathroom, as well as what happened in the downstairs family room. Do you see what happens on these things? So case in point, your seller had this happen 15 years ago, and they're going to say everything, no reoccurrence since then. 15 years is a good test of time. Here's what is not a good test of time via the courts. The listing agent goes to kick the tires and see about what they want, if they want to list the property. And the listing agent, in their great wisdom, says, oh my word, when did that happen? You know, they're looking at something and wondering when it happened. Oh, it happened years ago, but you think we ought to fix it now? And they said, oh, that's going to cause a problem. And it was water stains due to previous water damage. But they just fixed it. so they could get it on the market and it can show real well. See how a little treacherous that might be for some sellers? Now, true, if it hasn't had an event, that's fine, but when the buyers find out they just fixed it versus 5 years ago, because water does crazy things. It really does. And some sellers are just fine that they have water stains on their ceiling. They know what caused it. They fixed the cause of it, right? They fixed the vent, roof vent, where all the seal had come away and it seeped in because somebody here gets rain. We haven't had rain since June, where I just left, so we need it. But, you know, those are the kinds of things that cause issues where they're trying to fix it up just so they can sell it. The mic, she needs to be there.
Okay, I just want to make sure I'm understanding correctly. Let's say, okay, my house, and I know that 1 year, 2 years in a row, maybe the toilet overflowed. So that's the kind of thing that you'd be talking about, or in the case that I see a water spot in the ceiling and I repair it, but I really don't have any idea how it got there. I just happened to look up one day and notice it. Are those the kind of things that we need to disclose?
Any water damage.
So there are things that you see, you've observed, but you don't really know when it happened. So you're just stating that these things, that the water stain, but you, since you didn't know, you can't say what year, what month, what date that it occurred, but you would say that you,
Most sellers say, it was there when I bought it.
well, that's where I'm getting to. How would I, as a seller, explain something that I noticed it, I repaired it, but I have no idea how long it's been there?
Well, when you buy a property and any apparent water damage is notated, you're going to figure out the cause of it, or you're not going to buy the property. That's common sense. Some people may say, oh, I don't need to know what caused it, I'll just fix it. I don't know about you, but that's not what's going to stop it from recurring. But that's just me, go figure. I kind of look at it from that standpoint. But there are lots of buyers who bought properties, saw the water stain, and it wasn't wet, there was no moisture reading, so they're thinking, what? No big deal. But that's not most of the buyers that we represent. They want to really know what caused that and how was the cause of it fixed and repaired so that it won't recur.
Okay, great. So if the seller observes some damage and they repair it, they're obligated to disclose that there was damage. But if they don't know why it was caused, just disclosing that the damage occurred.
I'm not going to tell you what the seller should say, but
Okay,
they're
that's
going to
fine. Wrong
disclose
question. Gotcha.
every.
Just disclose
yeah.
what you know, but you can't disclose what you don't know, basically.
Yeah.
Okay, thank you.
I don't know, even though the courts say, you're not obligated to disclose something you don't know, the poor sellers have to prove that they didn't know it. See, that's the problem. And as it sits above your head every night as you're in the TV room, eventually you're going to want to fix that, find out what caused it. Yes.
Okay, I have a question too. So if a buyer bought a property and still has the seller disclosure from the event when he bought the property, and then maybe a couple of months later or a year later, he wants to sell the property, but he still has the old disclosure available, should the listing agent include that?
No. The seller will complete the disclosure that's valid by law at that time, and the buyer will incorporate everything they know from those previous disclosures.
Okay, so basically what he knows from the prior disclosure needs to go onto the new
Oh,
disclosure.
yeah. Even if he fixed it. Because somewhere along the line, somebody in their arsenal, I'm going to tell you what happened last week. One of the agents called me and they said, my buyer's interested in this property, and I asked the listing agent, was there an inspection report by the previous buyer? Because they saw that it had terminated. And the RE/MAX agent says, oh no, they terminated before they did anything. Well, the buyer's agent didn't believe that, picked up the phone and called the agent who represented the previous buyer. With that previous buyer's written permission, they gave that report to our buyer agent. And, it's the buyer's report, so the buyer had the right to do that. I said, you might not want to wave that like a flag, because really, if your buyer is that interested in the property, now they know a whole lot more. True, the sellers were not truthful because their agent wasn't truthful. But you might just want to keep that in your arsenal so that the buyer is aware of these things. And truthfully, once a buyer knows that the seller has representation that has assisted in concealment, that's when they need to run as well, period. There's no way that's ever going to work. We don't, it's a violation of the Code of Ethics and human decency to other people to assist in concealment, period. That's how it works. Now, in Section 3, as I said, that's going to cause the biggest issue because it always has. The buyers go into the property, maybe decide this weekend we're going to change out the cabinetry or something in the kitchen. This is what's happened since Harvey. And they remove the cabinetry, and now they see all the mold back there. Foundations are not level, are they? No. And what does water do? It seeks the lowest level. And so while visually it doesn't look like the floor is slanted, apparently it did slant right under the kitchen cabinets where the water went back there and trapped. But it, they were able to clean up the water, and it looked like what? There was no water damage, and there is serious water damage. In Section 4, it says if you're aware of any of items, equipment, or system in or on the property, notice in or on the property, that is in need of repair which has not previously been disclosed in this notice. So we went through Section 1, 2, and 3 with all these yes, no's, and unknowns, and now they're saying, hey, anything else about the property that you know you need to disclose. Section 4 is almost never completed. And it's a pretty big question posed to the sellers. And so again, those are the kinds of things you got to be on the lookout for. Now in Section 5, the new Section 5 starts the questions. 5, 6, and 7 are new sections that ask questions about flooding. Okay? And they asterisk it because at the very bottom of this form, so purposes of this notice, in other words, Trex said, we're going to define what we're asking the sellers to disclose. So they define the 100-year floodplain, 500, flood pool, flood insurance, floodway, reservoir. So they gave all the definitions so a seller could reference them to determine if they need help. If a seller turns to you and says, am I in a flood zone or whatever, you're going to say, you know who you need to get with? Your insurance agent. You are not going to answer any of those questions. Even though you can go out to websites that might be trusted and find out this information, you're not going to be the source of it. Their insurance agent is the one that's going to assist them with that. And the first question says, present flood insurance cover? If yes, attach TXR 1414. So now the disclosure has expanded to 2 more pages. Now, there's a huge lawsuit that's been going on in North Texas. We thought the Supreme Court of Texas would rule on it in June. Instead, they asked for more information. And here's what it revolves around. The listing agent presented to the buyer agent the seller's disclosure, the Texas Association of Realtors seller's disclosure. Buyer agent looks at it and says to the listing agent, you didn't give us the 1414. And the listing agent evidently was just too busy because it was repeated several times. We're missing this. On the day of closing, the very high-profile buyers terminated because they did not receive the completed seller's disclosure. Sellers, it was not an inexpensive property. Sellers had lawyers, and they said, you can't do that, I'm going to sue you. And then the buyers sued, and so it involved in a lawsuit to determine, did the buyers have the right to terminate because the seller's disclosure was not complete. Okay. The lower courts viewed with the buyers. Sellers had to pay all of the buyer's attorney fees, and the seller says, I don't know anything about this 1414, so now listing agent and broker, you pay all of this, which is true. There was proof that the listing agent had been even asked to provide it. Here's what I'm going to tell you. That's a universal form, the information about special flood hazard areas. And when I talked to you a little bit earlier, remember how I said as a listing agent, it is your duty to bundle the entire disclosure and send it? And when you do that, normally it's itemizing the attachments. It'll say seller's disclosure 1406. It'll say the addendum for lead-based paint. It will say TXR 1414, on-site sewer and septic 1470. In other words, it itemizes, and the listing agent can prove they delivered it. When the buyer agent gets it, it's when the buyer got it too, at the same time. Anything we receive, they receive. And because it was all bundled together, and the seller signed the TXR 1414, because there's only a place for two parties to sign. Doesn't say seller or buyer, doesn't say landlord or tenant. It's a universal form. When the buyer signed the seller's disclosure, and you've proved that you bundled all of it and delivered it, they're acknowledging all of it. So they received it. See, the law just says they have to receive it. So it would have been very easy for that listing agent to do that. I don't know why they didn't do it. Doesn't make any sense to me. As a listing agent, you can add boxes and signatories if you want the buyers to sign it. Some of the disclosures do require, like the lead-based paint addendum requires the buyer to sign and date it, mark their boxes. On-site sewer and septic, the same thing. But if you can prove as a listing agent that you bundled and delivered all of it, when they sign that disclosure, they have acknowledged that they have received it. That's your key. And again, we had a lawsuit not too long ago, and the listing agent had the email. It was perfect. They had delivered everything and all the itemized attachments. So it proved they delivered every last one of the required documents that were on the disclosure. That helped their seller. Seller could prove, oh no, you got this. Your agent just didn't give it to you. Okay? And that's not our problem. That's the other side's problem. So the next question says, previous flooding due to a failure or breach of a reservoir or controlled or emergency release of water from a reservoir. Well, that because of what happened in Hurricane Harvey, which is 2 years ago. It's unbelievable. The next question says, previous flooding due to a natural flood event. If yes, then you have to attach the 1440. What that means is any flooding on the property, period. The next question talks about in the structures, any improvement. So this would mean it jumped the curb, was on the front, over the sidewalk, on the driveway, any flooding onto the property. If water pools in the back, they have to also disclose all of that. So again, this question is about any flooding on the property. Okay, that's what the seller will disclose. Then the next question says, previous water penetration into a structure on the property due to a natural flood event. If yes, then 1414 has to be attached. And this is important because that question has to be explained. And when the seller says it was just a little bit of water, we've had some listing agents who said, oh, it only happened in the garage. They didn't have to disclose that. That is a structure. Let me tell you what really hurt a seller. You know these outdoor kitchens? They're awesome, right? So what happened is there's a foundation. The kitchen is on that. There's a roof over it, like a pergola. It wasn't a closed-in building, but there was a roof over the structure. Guess what floods? The outdoor kitchen. It's just happened to have been that it does that when there are heavy rains, right? Seller didn't disclose that. First time it rained very heavily this year, the buyers found out about it. And that was never disclosed. And the sellers didn't mean to leave it off, they just weren't thinking. And, that's a bad thing. That's, again, this is any structure on the property. It could be a pool house, could be an outdoor kitchen area, could be a patio, could be a garage. Any structure that's on the property that has ever had water penetration, they have to explain that. Then the next few questions ask, is it wholly or partly located in a 100-year floodplain, which has had the 1414, a 500-year floodplain, a floodway, which has required the 1414, a flood pool, or a reservoir? And if answer to any of the above is yes, then they have to explain each one of them or attach additional pages that would be necessary to complete the explanation. The next question, and have you, seller, ever filed a claim for flood damage to the property with any insurance provider, including the National Flood Insurance Program? Buyers need to know this, okay? They talk about lenders. If there's a lender on the loan, they most likely required flood insurance because of certain flood zones and those type of things. Section 7 says, have you, seller, ever received assistance from FEMA or the U.S. Small Business Administration for flood damage to the property? The buyers have to know any and all claims that were ever made, because our homeowners policy doesn't cover flood. And a CLUE report only turns up any of the loss underwriting history on the property, but not with a claim, because a flood claim would come under other insurances, not our homeowner's insurance. So they have to be extremely truthful on this, and then the buyer, as a buyer's agent, knows this. Once the buyer gets any information that might lend itself to having to further investigate, when does the buyer do that? During their termination option. Okay, that's when they have to do their due diligence. Now, Section 8, the last question says, any portion of the property that is located in a groundwater conservation district or a subsidence district, every property you sell is in one of those. It's a law. It is, the map has been available to you. What incenses me is anything you know as a listing agent, your sellers would need to know. So instead of assisting them in completing the seller's disclosure, you're going to go through this at the time of listing, attach that map, circle it, and let them know, because now when they get asked that question and you're not in the neighborhood, they already know this property is in one. Yes. We need a microphone right behind you. Thank you.
So if one's using Seller's Shield, does 1414 automatically pop up if they answer yes to question 1?
Yeah, they have the other documents that are necessary. I know they were queuing the buyer listing agent to say you might need to attach the others. They were working on that, so I don't know.
Well, this is very valuable because I see 1414 is not completed through Seller's Shield for my listing. So
Right, but they'll give you a notice because of their why answers.
yeah,
That you need to attach the other addendums that are necessary and other notices.
I will do that today. Thank you.
You're welcome.
Hi, Marilyn?
Is there a microphone over there on that other side? There's somebody way back there that needs it too.
Hi, Marilyn. So for Section 8, attached map of, I'm sorry, I didn't catch that.
It's the state of Texas on the TCEQ website, which shows all the water districts in the state of Texas. Not the entire state has one, but a lot of areas do. And your question? Yep. Now, 9, 10, 11, 12, 13, and 14, they've just all been renumbered, and one day it'll be 300 pages on a seller's disclosure. But I want to point out something. Look on page 6 real quick, and I want every buyer's agent to do this. This will protect you. Now, what happens on this, you can use a copy that they're not going to acknowledge or something like that, but what I want you to do is circle paragraph 5. And have your buyer's initial inside it. Not one that you'll present to the sellers, but the one that you're going to keep forever. And it says, if you are basing your offers on square footage, measurements, or boundaries, you should have those items independently measured to verify any reported information. On page 6, paragraph 5. And so what happens on that, the buyers have to say, well, what do you mean by that? Well, you're not going to rely upon what's in MLS, on the appraisal district. If you're really hung up on square footage, our contracts don't have any mention of square footage. You don't have the ability to terminate if square footage comes up. All we look at is value, and value is paragraph 3, right? 3C, sales price. So I want to protect you because we have had too many issues as of late. The property actually met value, but the buyers saw a different number than what the listing agents put in MLS or what was auto-populated. And there was a recent lawsuit in the state of Texas, and the buyer sued the listing agent and said, you gave misrepresented information in your MLS. And it was proved because it auto-populated from the appraisal district. So the listing agent was exonerated from it, okay? My problem for you is the listing agent should receive the offer with the HAR 410, which is the broker tenant notice. It clearly states that nobody's at fault and don't rely upon any of the measurements in MLS. Okay, but if you're a listing agent and you don't ask for that and the buyer agent doesn't give it to you, buyer and tenant agents are both supposed to present that at time of lease offer as well as purchase offer. But listing agents sometimes don't ask for that, but that's a very important one because you're clearing up that, hey, it's not my fault because the appraisal district has had the square footage wrong forever. Most of our sellers ask two questions. Number one, they ask the buyer's agent, did the property appraise for more than sales price? Buyer agent cannot lie. If they know, they cannot lie. And so the buyer has to understand that, man, if that other agent asks me if it met value or exceeded value, and I know now that it does, I cannot hide that from them when they ask. And so one buyer agent last week said, you know, Marilyn, the listing agent never asked that. I said, well, that would be the first question I asked, because an amendment was sent over to reduce the sales price by $13,000 because square footage was different from the appraisal the buyer got versus the appraisal district that was auto-filled. And they wanted a $13,000 reduction when it had exceeded value. Now, I don't know about you, but the seller's response back finding out that they wanted a $13,000 reduction when it had exceeded in the appraisal, the sales price, the seller's response couldn't even be printed. And so because, well, don't you think a seller would say, I don't think so, right? But we've had a lot of listing agents that don't advise their sellers properly or find out this information. And the poor sellers feel what? They feel they're hijacked at the very end. They have to give in or the property won't close. And that's not a good thing. Again, there's nothing in our contracts about square footage. Yes?
So the answer is yes or no exceeded appraisal. You don't have to give them how much it exceeded, correct?
If they ask you, you would.
Okay. Wow.
Once you know, you cannot lie. And see, that's the problem. The buyers didn't understand that the buyer agent said, oh no, if they ask me, I have to disclose. Now my thing was, back even in the 90s, I would say, all I want to know, did it meet value? I wanted no other number or anything, because I know how crazy people are. So that's all I wanted to know from my seller. Did it meet value? And as a buyer's agent, that's all I wanted to know. If it didn't meet value, we had a whole different other discussions and amendments and other things. But in case of a buyer saying, the listing agent said it was X number of square feet and it's not based on my appraisal, I just want you as buyer's agents to be protected. Take a copy of this, have them initial inside of it so they absolutely know they don't get to ask this question after they finish their termination option. If it didn't meet value, that's a different issue entirely. But if it met value and square footage was off, that's what you want to do. Now, Section 6, we have a lot of sellers who don't complete that. But we had some sellers who do. And you know what? There's some information sometimes they put in here that buyers really need to read. In other words, when it asked about gas, the seller wrote in here, capped off in 2013. And the buyer freaked out because they have this gas dryer that they love. And it had always been there that it was capped off. Okay, so again, it's important a buyer sometimes receive this information. I love it when Section 6 is completed. Most of the time it has saved the sellers. We had one on the sewer. On the on-site sewer, they let their required contract for an aerobic septic system lapse. They had moved out a year before and they just let it lapse. And they put all that information right here, but the buyer and the buyer agent didn't read it. Okay, which is kind of important to do that. So again, this seller's disclosure, now being 6 pages, you can see that there are times when a seller feels like, well, if I tell them that, I'm never going to sell my property. No, that's not the case. It just may be the reality check for the seller understanding what? The true condition of their property. That's that back to that whole pre-listing inspection report, because sometimes it helps tremendously on being able to figure that out. Okay, now what has to happen on September 1st? And everybody know when September 1st is? It's Sunday. So here's what happens for a listing agent. You have to get the new disclosure completed. It's been in update since in dotloop since August 1st. You're going to go to your sellers and say, I have to assist you in complying with the law. The law mandates it. that you must complete a new disclosure. And the reason we're going to do it today is because in the event you get an offer today, if you executed it Sunday and you had the old disclosure, you've all violated the law. No, it is. It has nothing to do with the contract. The notice is not a part of it. It's just they violated the law. The law changes and it goes into effect September 1st. That's Sunday. You don't ever help people violate the law because they're going to blame you for that. Okay? So as a listing agent, you have to have that done. It's your responsibility to help the sellers comply with it. And here's what Texas Realtors attorneys wrote about it. The revised version of the seller's disclosure notice must be used in transactions when the sales contract is executed on or after September 1st, 2019. It may also be used on a voluntary basis for transactions where the contract is executed prior to that date. And again, as I said, we've had it out there since August 1st. The problem for the listing agent, if the seller says, I'm not going to complete it, in your sweetest voice possible, you're going to go back to the seller and say, oh no, I do not want you to breach our listing agreement. You promised in paragraph 12 that in the event anything changes on it that you are going to complete it, because my brokerage would be entitled to the compensation right now and I haven't even sold your home and I want to sell your home. That's exactly what you said in the sweetest possible voice. And it's paragraph 12. And every agent who's called me because they've had these issues, I said, this is what you say to them. The next thing they call me back 2 days later, they go, the seller completed it. They updated it. And that's how you have to do, because in paragraph 12, we're assisting them in requirements of law. Okay? We don't represent parties who will not comply with the law. You're just asking for trouble, okay? And this came from Texas Realtors. It didn't come from Maryland. It came from Texas Realtors. That's what's going to be really valuable for you to have that information handy, especially when, as a buyer's agent, we'll talk about that. But a listing agent, that's your job. And you wouldn't go forward with anybody. You would just collect your commission. And it's going to be really interesting when they actually read the listing agreement, you know, and they see that type of thing. So again, it's no fill in the blank. It's just there. Nobody reads it, but it's right there in paragraph 12. So we're just not going to make a mistake on something like this. Now, buyer's agents, this is something different. You don't have any input as to advising a seller. You represent the buyer. You ask for the seller's disclosure. The listing agent sends it over. It's September 1st. And it's the old seller's disclosure. You're going to immediately let your buyers know that the sellers were required by law to provide the new disclosure today. The listing agent says, good luck on that, you're not getting it. Put it in writing to the buyer and ask them how they want to proceed, okay? If they said, Marilyn, no, I really want this property, which is what they always say, you're going to say, okay, but here's what you have to do. I'm going to provide you the new seller's disclosure. Here's the old one that they presented. You need to do a comparison of all of it and then find out any questions you want the seller to answer that they did not have on the previous disclosure. So you're going to put that in writing. It's going to be the buyer's job. Okay, you better save all those emails, okay? Please do, because it's to your benefit. We can't enforce a lot of that, but we certainly can tell the other party in writing, you did not provide what is required by law. Okay, I've let my buyer know that. Will you provide the update? And the listing agent goes silent, right? Well, then you're going to mark 7B2 in the contract, which now means the seller is required contractually to provide you the new seller's disclosure. Because the moment if they try and give you the old one, say, no, that's not going to comply with the contract terms, you are required by law to provide the new disclosure dated September 1st, 2019. So don't let the seller agent get away with it. Make sure you do that in benefit of your buyer. The buyer will know all of this in writing, what's going on. The other thing you have to do is if they provide you the new TREC disclosure, not the old one, but say the new one, you're going to have to do the same thing and saying, this disclosure doesn't let the seller answer as many questions. It is the minimum requirement of law. What I am going to give to you is the new Texas Realtors one. You're going to do a side-by-side comparison, find out if there are any questions you want the seller to ask, and then I'll ask the listing agent to get the answers for you. You have to do that when they use the TREC one too, because we know that the sellers are not asked as many questions about the condition of the property as we are on the Texas Realtors. I just want you to be protected as a buyer agent, that you've shown that you've tried to do everything in the best interest of the buyer, but the buyer might say, I don't care. Get that in writing, don't get that over the phone, or get it confirmed in that email that you sent out to them explaining the differences and showing them the form. You don't have to sit down and compare them. You're going to make them compare it. That's their job, okay? Just remember it. You provided it to them. And again, that part in yellow is what is required, and your buyers need to know this. This is not something you made up. This has gone out. I've sent out notices to all the brokers August 1st. Tell the agents. We're going to have to send it out again because we're coming up to the deadline on something like that. And here's what I'm going to tell you, the saddest story of all. There's an agent who had a complaint, and the complaint was about that the sellers marked on the old disclosure that they have flood insurance. The question doesn't say, is it mandatory? It just says, or do you have flood insurance, right? And the sellers marked yes. Listing agent didn't give them the 1414. And so the buyer got very upset because they found out that they were not individually approved when they found out how much the flood insurance was going to cost. And they didn't do that during their termination option. We didn't represent that buyer, we represented the seller, but we passed it along. So I'm visiting with the agent last week, confirming her response and stuff for the broker, and I said, you used a disclosure that was repealed twice by law. She says, what? No, that was in .loop. I said, well, it hadn't been in .loop since 2017. And she used a 2016 seller's disclosure. And so she's petrified. I said, you won't lose your license. It is a violation because the law changed. See, Texas Realtors forms changed, but the law doesn't change. That's different. Okay? Everybody understand that? When the law changes, because the governor signed it into law, these changes, when that governor does that, and that's every 2 years when they're in session, that's when it happens, and there's changes on the TREC seller's disclosure, Texas Realtors puts them in their disclosure. But there are times when Texas Realtors, because of the lawsuits brokerages have been in, and they ask us every year, if we could advise them, is there something if we added to the disclosure, would it have helped you, right? And we tell them, it should have been clearer about this question, make the language clearer. Water damage instead of water penetration, because it's not water penetration, it's just water damage. So all these things we've always advised them of, but they choose at certain times to incorporate them and then publish a new disclosure through Texas Realtors. But 2016, it was been repealed by law. And so that puts this agent, listing agent, in a different light, even though the complaint is that the buyer wanted their earnest money back, but they didn't have the right to terminate and give notice because they were no longer individually approved. So they're trying to blame the listing agent now and the seller that they didn't get their earnest money back because the seller did not tell them it was mandated. It's not mandated. It's lender discretion. And that's in the new disclosure. You know where it says that on that question, that lenders many times are saying if it's in the flood zone, I require flood insurance. But everybody in this area should have flood insurance. You know what I'm saying? The question doesn't say, is it mandated? It just says, is there present flood insurance? So we would have been fine had she not had a repealed seller's disclosure. And that's sad, just on something like that. So it is very important as a listing agent, that's what you have to comply with. Buyer's agent, you've just got more work, more extra steps that you're going to have to go through to explain it to the buyer why the seller's not doing what they should be doing on something like that.
On a piece of property where there's a curb, grass, sidewalk, and then the yard. The owner owns everything from the sidewalk to the house. They may be responsible for maintaining everything from the sidewalk to the curb, but that's actually an easement. If the water goes over the curb during Harvey, is that flooding on the
We're
property?
not going to split hairs here. I'd disclose it.
Okay, that's what I wanted to
Yeah.
know.
I-
Can we tell somebody that they need to disclose that or not?
I'd tell them it's in your best interest to disclose any water that came onto the property, even the easement that you keep mowing,
Right, okay.
your driveway. So don't, any question you're going to ask me, I'm going to say yes.
Okay, thank you.
That's how it works on something like that, because I would never want somebody not to disclose something. And just like the question when they went into Seller Shield, all of a sudden they found a newfound way to disclose things they didn't even know they had, but they were going to say, I do have them, you know, that kind of thing. It's just because they give legal advice to the sellers as they're completing it, telling them, be careful, make sure you do this, and pops up and tells them all these things. Again, that's the one form that is why we get sued. Normally, we take care of all those other kind of issues that come up, but condition of property doesn't go away. It goes away with lots of dollars many times and lots of litigation cost on something like that. Now, we're going to get to the next part, which is really disclosing what had come to pass. And I'll tell you how this happened. I work for Levin Keller Williams offices. We have a lot of investors in some of our areas, and here in particular, those investors went in, bought the property that was flooded, and fixed it up. On one lawsuit, we had where we got, because of discovery, we asked for all the documents that the flipper, when they bought the property, got, right? Sure enough, they had, in their contract form, they didn't want the seller to give them a seller's disclosure because they wanted to not tell any future buyers what the sellers of the property knew. And they marked the little box in 7 that said, we're exempt under the Texas Property Code. And no seller was exempt, none. So the problem is, you see the weave it was starting to make. And the poor listing agent, they're representing this investor flipper in the best possible way. But what it came down to was not only did they not disclose it, and the listing agent did not verify some things that are a public record, and that's Trex looking at it that, and all the attorneys who sue you, they're looking at it like, oh, if you don't work in this area and know firsthand about it, you shouldn't be listing the property. You know, they're putting that, you should know that it flooded not once, not twice, but 3 times, those kind of things. You can't bury your head in the sand, is basically what they're saying to the listing agent. But under this issue, it came up that the flipper did not use workmanlike quality in the updates, in the repairs of it. And so what happened is they are required, just like builders are in the statute, to warn to the buyer that the repairs were performed in a good and workmanlike manner. And unless this contract contains a warranty that would be deemed sufficient by a court, line is, it would be devastating for that flipper who sold the property. Our promulgated forms don't have it on the 1-4. And it was a result of Melody Home warranty lawsuits. And this attorney pled before the Supreme Court on this case. And here's what they recommended, that an investor would hire a real estate attorney to create this addendum. And then they'd have to add that it's not a promulgated form and blah, 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 all these other things that everybody who adds something that's not promulgated. But it says, seller warrants that any repairs and improvements seller made to the property were performed in a good and workmanlike manner. God bless you. Seller hereby transfers any existing warranties on the property to buyer and authorizes buyer to take any actions necessary to effect such transfers. We have a paragraph 7 that's like that now, but in particular regarding their warranties that they're going to provide to them. It says seller will identify all known existing warranties to buyer as of the date of closing. Buyer will have the responsibility to ensure that any requirements for transfer are satisfied. And in this 1-4 family, none of that was there. And it was kind of proven that the investor didn't use good workmanlike quality in making the repairs or updates. And it has caused problems for the listing agent because you weren't aware that the law affects them and what they should know. Sometimes when they come to you, they could be a first timer. That's usually the devastating thing because they're going to look to you to tell them everything they need to know about the situation. I wanted to bring it to your attention because we're getting way too many of them. Now, as a buyer's agent, I'm just going to tell you, your antenna is going to go up and red flags are going to go up everywhere. If you have a buyer who is acquiring a property from a flipper, and it's not to say that the flipper hasn't used good workmanlike quality and products, but there's a lot of issues involved in that, especially on the seller's disclosure when it says unknown and everything, and they've been in the house the whole time remodeling it, fixing it up, and those type of things. We've had issues where while the builder, remodeler, fixed everything up really well, got good things, unfortunately they got into dispute with one of the vendors. And on the day of closing, the flipper gave a check to one of the contractors for the work that was done. And then after closing, the seller stopped payment on the check. So because they got into a dispute with it. They needed it closed, and the only way they were going to get it closed was for that contractor to release anything, tell title, yeah, this has been paid, blah, blah, blah. Well, the reason was they got into dispute, and then the new buyer, new owner of the property, gets a lien on the property. So as a buyer's agent, there is a place in our paragraph, it's called special provisions. We're not able to write anything legally, but we can write business facts. And a buyer surely can write in there a business facts that seller will provide all release of liens of any contractor that performed any work on this property prior to closing and funding. Buyer requires seller provide a release of lien from all contractors that performed any work on this property by closing and funding. And while title does their search, it doesn't come up. Or it could come up. We had the situation that I think I told you about the builder, very large builder here in Houston. Okay, buyer requires seller to provide release of lien from any contractor that performed work on this property by closing and funding, or at closing and funding. That's a fact. Did I say, or you're going to turn into a pumpkin, or I get to terminate? No. See, I wrote no contingency language. I wrote factual information. And business facts are able to be conveyed between the parties in special provisions. If they want something that's going to have legal teeth, they're going to have to hire a real estate attorney to write all of that, because we don't do that. But again, my biggest concern is we've had buyer's agents who got those horrible calls afterwards, and they said, well, why didn't you know that? That was a flipper. You should have told me this. And as I said, our antenna goes up because this is one of those situations that has caused us a lot of problems. And as a buyer's agent, you don't want that. But the other thing I'm going to tell you is that this builder, a very large builder here, they're nationwide, at closing, the title company, that's just like this with the builder, have you ever known that? Yes. Shoved over at the closing table to the buyers. Well, the agent happened to be the buyer. And so the agent read it, and she and her husband signed it. Move in. And now they have a lien on their property. And she called me. She says, and she'd been calling me because she'd had problems with the builder not finishing on time, and she had to extend her month to month at the apartment. It was costing her a lot of money. Anyway, the interesting part is when I read it, I said, but you and your husband signed it. Yes. I said, did you read it? Well, we read it, but I didn't understand it. I said, would you have ever done that with your buyer? Oh, no. Well, that's true. We do crazy things for ourselves that we wouldn't do when we represent other parties. And it was very clear. It was an incomplete form. It says that they're in dispute with this painting contractor for X number of dollars, and the dispute will be finalized, and it had a place for the date, and it was blank. I said, why did you sign that? It was blank. I don't know. We just wanted we were so tired of living in the apartment. You know all the excuses we hear from our buyers? Okay. So anyway, that night, she goes out in the cul-de-sac. Does anybody know what cul-de-sacs do? Yeah. They bring all the people together. Yeah. And 6 of the people that were in that area cul-de-sac, they all got the same liens from the contractor, but just different amounts based upon how much. And the agent kept saying, Marilyn, this painter never came in and did any work while we owned it. I said, no, because you got the disclosure before you closed. That was when they contracted through the builder. No buyer would have ever signed that. But what I did tell her is I said, well, here's what you're going to tell them. You're going to tell them they either clear that today by 5 p.m. or the risk manager who helps thousands of agents and brokerages in this city will tell every last one of them what that builder did. You think it was resolved? Yes. But, I mean, I couldn't imagine that this builder would ever want that. Do you know what I'm saying? There was a time in this city when they wouldn't cooperate with us and they sold new homes. Most of you weren't born yet, but that's the way it was. They didn't need us until the market dropped and the savings and loan industry nearly killed growth in building in Texas. And then all of a sudden the builders thought the realtors are our new best friends. And they started cooperating with us. And I, you know, as I said, I was born and raised here. I know all these builders that were here for a long, long time and some of the new ones. But that was not acceptable. If our own client had been shoved across the table, I do not like that when something gets shoved across the table and I haven't been able to put my eyes on it and I represented them. Do you know what I'm saying? And it was very clear it wasn't completed. Even in the poor agent, she just said, oh, we should never have signed that. I said, well, it was blank. It blanked where they said they would finalize the dispute. I could see you signing it if they said within two days or 5 days they were going to resolve it, because their attorneys were on it who was handling the dispute, but no date to resolve it. And nobody wants to get a lien after they bought a property thinking what? This was all cleared up. Well, it was accepted from the title insurance because the buyer signed an acknowledgement saying it was.
So you would just not sign it?
No, I wouldn't sign it. They either get that release for my property only, and then we'll go forward and sign. I don't care about those other cul-de-sac people. I didn't represent them. And there's something evil about a cul-de-sac. I've lived in several. But it's just like, it's almost like it's an easy way for people to come out and tattle on everything they see. You know? And I don't know if you've ever lived in a community where people watch all your comings and goings. Lordy. You know, it is a nightmare. So it always seems to be cul-de-sacs for some odd reason. Everybody always loves cul-de-sacs, right? Yes, less traffic on something like that. Yes. But again, my biggest concern for you, if you're a listing agent, is to make sure that at no time you get an indication that the seller is not being truthful. The worst part is if you don't have a completed form. That's what I worry the most about, because every box must be marked. You don't send it over to the other party and not have a completed form. We don't get to say if it's correct or not unless we know something. And if we know something, what? We have to say something. Okay, that's who we represent on something like that. As a buyer's agent, you're never going to let your buyers think, oh, the seller said blah, blah, blah. Their seller is required by law to provide it. It doesn't mean the seller has told the truth or that the buyer can rely upon it. They can't. They have to do their independent investigation. They should have inspections by everything. I am going to tell you, if the seller says anything that's in need of repair or is not in good working order, that's a huge red flag. That's going to be on the list, because when the inspector comes out to inspect it, the buyer's going to bring that to their inspector's attention. And then the inspector will probably add notations about what they recommend you do. And so the moment the inspector says you need to have an HVAC, determine that, they're going to probably need to extend the termination option. Don't get out of that time frame. Do their due diligence, hire an HVAC company to come back and tell the buyer what they have found to be. Anytime we rely upon a seller to tell us, it's not the same. The seller's going to see it differently. Oh, that's fine. We've always lived with it that way. It's no big deal. And, the problem is you get the calls. You get the calls if you're the buyer's agent, or you get the calls if you're a listing agent. If there's some issue or dispute about the condition of the property after it closes in funds. And so the only way that we can do that is to ensure that we provide complete documents. Listing agents, we have a great provision in the listing agreement. If the seller was aware of something and purposely didn't disclose it, that's called fraud. And they have to indemnify us, and that's a whole different matter. There's a microphone, there we go. Can you pass that to her?
Is there anything we can do about the relocation deals where the relocation company creates that gap between the original seller and the new buyer?
I don't think so. I'll tell you.
Because I've had a buyer who bought one, and I explained that they weren't getting the seller's disclosure, that there was this firewall, so to speak, but they do give the seller's disclosure from the
previous
original owner, but there were flat out lies on that.
I know.
That we didn't buy from them. There's nothing we can do about that?
I don't think so. As I said, other than litigation, and you'd have to prove damages and that type of thing. But that's one thing that has irritated me to death. I hate it because they suck in the listing agents. As I know, I was a listing agent for relocation, and I felt I was really a property manager. And so even though the relocation company has this listing agreement that says if I disclose anything about the property without their permission, which is different than our law in the state of Texas. And I didn't care what the relocation company had in their listing agreement. I disclosed everything I knew. Mainly because I cannot hide that. I will be subject to the law in the state of Texas. And anything I know. And it just irritates me about the relocation companies that tend to do that. They don't want to acknowledge, and they paid all the darn receipts for all the work that was done on the property and other things. So it's difficult to do anything to change that element of the only thing that's going to change it is to have really good listing agents who represent them. As I said, I always disclosed everything. My husband worked for the company, and the relocation company was a subsidiary of AT&T, and all the commission I paid to that subsidiary went to the benefit of the employees. So they weren't going to trap me into not disclosing everything. And the neighbors always knew me because I did open houses. And, I'd ask them for help if you know anybody who'd like to do it. And so the moment the neighbors would see anything, because it was a vacant home, the employees had been moved on. And the minute anything would happen, those neighbors would call me. And then I'd have to round up everybody who was an able-bodied person to help me go put the fence back up because a twister came through and knocked it down, or a tree broke. You know what I'm saying? I was the property manager. And nobody can say that I won't disclose that. But the listing agreements, if they don't use our association forms, they have their own. And it's very damaging if you sign any listing agreement by them, because they can hold it that you'll have to indemnify them if you fully disclose the truth. Isn't that crazy? Doesn't even make sense on something like that. Real quickly before you go, if you have buyers that are interested in buying properties from Zillow, OfferPad, any of those companies, be very, very careful. On the top of our seller's disclosure for the Texas Realtors, it says it complies with Texas Property Code 5.008. You won't get that from any other company. In fact, we had one last week from Zillow, and they put an Arizona form by Zillow in the documents for disclosure. That's just insane. But does the buyer want the property? Oh, yes. So, the poor buyer's agent had to disclose all of these things and pointed out, all these different things that it doesn't comply with the law. They disclose, but here's the Texas Realtors one, do a side-by-side comparison, find out if you want to know anymore. Just as a buyer's agent, be very careful of those scenarios, okay? Because they're not complying with the law.
Hi, Marilyn. Last question. So from the seller's disclosure notice, as long as your contract is before, you've got a signed contract where both the seller and buyer have agreed to the sale of the house, then you do or you do not have to do the new seller's disclosure.
Any contract executed prior to September 1st can have the existing disclosure. Anything as of September 1st and after must have the new seller's disclosure requirement of law. All right, next month, we're going to go through all the changes so we can know all the different changes on the addendum and the contract form. Have a good one, everybody, and happy Labor Day. Thank you.